Welcome to the week number 6 overview for economic analysis of the law. And in this particular week, we're taking a look at Chapter 6, an economic theory of tort law. And one of the sections, or the first one, is that takes a look at what occurs when there are changes in the level of legal duty of care. So realize that, for example, that there's a legal duty of care that's set at X asterisk, which is equal to the social cost minimizing level of care. Now suppose that a technology or precaution lowers the cost of the precaution so that social minimizing level of care increases to, let's say, X star. So there's a change in technology or decreasing price that increases the level of care to a higher level. What occurs is that there's a issue that comes up that potential injurers will continue to adhere to the lower level of care instead of increasing their level of precaution to the new cost minimizing level. So realize that this is an issue that occurs. So the questions that oftentimes come up are there forces that will induce potential injurers to increase their level of care to the new optimum? Should lawyers advise their clients to increase their precaution when this technological change or decrease in price occurs? Would there be a competitive advantage to those firms that increase their precaution to the new level? So make sure you realize this, that when firms are taking precaution, the role that technological change causes or a lowering of the cost of precaution changes, and taking a look at the firms of whether or not they are going to adopt that new legal standard and whether or not lawyers should advise them to increase their level of precaution because of the technological change or a decrease in the price. Also, there's another important thing to realize here is that the level of activity has an effect on accidents. The idea here is that there are some activities such as automobile driving and serving restaurant meals in which there is an independent positive effect on the probability of harm arising from the quantity of the underlying activity which the potential tortfeasor is engaging. To give you a very extreme example, if you do not drive a car, then there's a zero probability that you will injure someone in an automobile accident. However, the more miles you drive, the more likely it is that you will injure or be injured by someone. So it's very difficult to include this notion of activity level when it comes to liability issues. Remember, we talked about efficiency, and the idea is that negligence does not take appropriate account of activity level effect, but that strict liability does. So make sure you understand that when you have negligence, i.e., both parties can be negligent, versus strict liability where only one party is negligent, that there's a differing effect between the two. The reason is that negligence simply establishes a list of identifiable behaviors, compliance with which will exonerate the decision maker. So there's a list of behaviors that you can engage in, and that if you engage in those activities, you're exonerated, you're no longer at fault. So when there's negligence, meaning that both parties can be negligent, there's a system that's set in place that has identifiable behaviors. But the activity level effect does not. Some say that it could not figure into a negligence calculation. By contrast, strict liability simply delegates to the potential wrongdoer the responsibility for minimizing the cost of accidents in whatever manner he or she is able to do. So realize that because the responsibility for accident losses lies entirely on the wrongdoer, and because there is no way in which to escape that responsibility, that is, that there's no exonerating level of care, the potential tortfeasor subject to strict liability has every incentive to find every means he can of reducing his or her expected accident costs. So if they are strictly liable, there is an incentive to decrease that liability, whereas when there's negligence, there's little to no incentive to do so. If there is an activity level effect, he or she has an incentive to discover it and to take it into account in determining how much of the underlying activity to do. For that reason, strict liability is superior to negligence as a means of getting potential tortfeasors to take account of activity levels. So make sure you realize that strict liability is superior to negligence as a means of getting potential tortfeasors to take into account their level of activity when it comes to liability. Also realize this notion of error costs. Law and economics literature's findings is that the circumstances in which negligence and strict liability are appropriate are different. So realize that there is some level of discussion about negligence versus strict liability and when they are appropriate. There are other factors mentioned in the text, but the central one is that negligence is more appropriate for situations of bilateral precaution and strict liability for situations of unilateral precaution. So realize that the negligence standard is more appropriate when both parties can mitigate the probability and the cost of an accident. Contrast that to strict liability for situations when only one party has the ability to impact the probability or the costs of a particular accident. The matching on the grounds of efficiency of liability standards with certain types of accidents raises an interesting question of legal error. What if tort law uses an inappropriate standard? That is, what if the law seeks to determine liability according to a negligence standard when it should have used the strict liability standard, or according to strict liability standard when it should have used the negligence standard? This could happen simply through inattention or because a court, even one well-informed in economics, was not sure whether a particular accident type was one of bilateral or unilateral precaution. In the latter case, the court should presumably want to know what costs it might be imposing on future parties and society if it guesses wrong. Consideration of these possibilities can make for an interesting topic for the particular class or an exam question. Consider the case in which the law inappropriately uses strict liability when it should, if it were pursuing only efficiency, have used negligence. If the potential parties know that the court will make this mistake, which they may not actually know, there may be inefficient consequences. So the misapplication of that can have inefficient consequences. Potential injurers will know there is nothing that they can do to evade liability, but as we have seen in the text, this fact alone should not cause inefficiency. Potential injurers will take the same amount of precaution whether the liability standard is negligence or strict liability, but potential victims will recognize that they will not bear residual liability, even though there are actions they can take to reduce the probability or severity of an accident. So realize that if it's misapplied, and if it should on an efficiency standard been negligence versus strict liability, some individuals who can be injured will have no incentive to reduce the probability that they are actually injured. Now consider the other possible error. The law uses negligence where it should have used strict liability. This might occur where there is, say, unilateral precaution. Only the potential injurer can realistically take action to reduce the probability or severity of an accident. Potential injurers will take the exonerating level of care and thereby escape liability, shifting the responsibility for the accident losses onto potential victims. Those victims cannot, by assumption, take precautionary accidents to reduce this residual liability. They must simply bear those losses. One might argue that this is not necessarily inefficient in the sense that there will not be a greater likelihood of accidents, nor will those that occur be any more severe than they would have been had the liability standard been correct. But there may be distributive injustice. What if potential victims could purchase first-party insurance? How would they respond to this legal error? Will the common law process be able to correct this legal error? So just realize that the two issues of misapplying negligence versus liability can lead to inefficiencies on the parties of the tortfeasor, the injury causer, or the person that is actually injured. And finally, this chapter takes a look at rules versus standards. The distinction between negligence liability and strict liability illustrates a recurring theme in the law, that between a standard and a rule. Negligence or fault is a standard. Behave reasonably, with a determination of what is reasonable to be made on a case-by-case basis. A standard delegates a great deal of discretion to the decision makers and requires him or her to make a guess at what the court will deem to be acceptable. So realize this notion of reasonable care, there is a great deal of uncertainty what that reasonable level of care is. So this might induce potential injurers to actually overdo trying to mitigate the costs of accidents or the probability of accidents. It also puts a burden on the parties. If there is an accident in a trial, of presenting facts to a court to establish whether the behavior prior to the accident was reasonable. So the fact of going to court over this and just making a determination about the behavior imposes cost. In contrast, a rule establishes a much brighter and clearer guideline, oftentimes referred to as the bright line rule, as to the duties of the parties. An example is posted speed limit. A rule tends to have two virtues. First, it relieves the decision maker whose behavior the law seems to affect of having to guess about what the law will deem appropriate. A rule economizes on a decision maker's knowledge requirements. He or she knows that the law expects her, and therefore her ability to comply with the requirement should not be in question. Second, a rule makes it easier for legal decision makers, courts, or other governmental agents to evaluate whether parties have complied with the law. The question before the legal decision maker is not whether the party's behavior was reasonable, but whether it was in the bounds set by the rule. So make sure you understand the difference between having rules versus standards. The standard we talked about was behaving reasonable, taking reasonable actions, and there's uncertainty with that, and also there's the cost of going to court in order to determine whether or not the activities were actually reasonable, whereas you have a rule, it eliminates a lot of those costs. It eliminates the uncertainty to the individual who's trying to take reasonable care, because if they follow the speed limit, they were taking reasonable care. So make sure you understand these implications as it relates to the chapter itself.